Good afternoon. It's been really tough to avoid news stories about the Wells Fargo fraud scandal. Starting in 2011, the bank's employees opened more than 2 million sham accounts, bank accounts and credit card accounts without the knowledge or consent of consumers from across the country. Customers learned of the scheme only when they started getting hit with fees for those fake accounts or noticed that their credit was mysteriously taking a hit. I've been the victim of fraud and identity theft myself, so I know how jarring and difficult it can be. But when it's fraud on a massive scale, committed by a financial institution where you were a customer, where you placed your trust, the sense of violation has to be even worse. To add insult to injury, when victims sought to hold Wells Fargo accountable, their path to the courthouse was blocked. Arbitration clauses were hidden in the fine print of the original legitimate contracts they had signed, sometimes years earlier, to open a bank account. Disturbingly, Wells Fargo was able to successfully argue the arbitration clauses hidden in those original contracts so that they could be used to force disputes over fraudulently created accounts into arbitration. So instead of being able to access our public courts and recover damages, the bank's victims were forced into secret, binding arbitrations overseen by an arbitrator hired by the bank. The idea that consumers can be blocked from our public courts when their bank commits fraud and identity theft against them is simply un-American. With the fraud cases locked behind closed doors, Wells Fargo kept the scheme hidden from broader public disclosure, allowing it to mushroom. And boy, did it. The result is a nationwide scandal that has cost Wells Fargo tens of thousands of customers, undercut the bank's bottom line, and undermined public trust in our financial institutions nationwide. Allowing victims their day in court helps them recover and can prevent more victims by putting an end to these illegal business practices. My measure, SB 33, will help prevent such a rampant campaign of deception from ever happening in California again. If SB 33 was already law, Wells Fargo would have been held publicly accountable years ago and prevented that fraud from spreading as far and wide as it did. It is a simple and direct bill. It covers only the activities of banks and financial institutions like Wells Fargo. It's not anti-arbitration. It only prohibits mandatory arbitrations in cases of fraud and identity theft. This measure safeguards our most vulnerable citizens, and among those specifically targeted by Wells Fargo were the elderly, the working poor, new immigrants grappling with a language barrier, small businesses, and students learning how to balance their checkbooks. SB 33 will make certain that the bright light of public disclosure shines upon these financial institutions. My bill will also act as a deterrent to future fraud. Companies will be on notice that if they commit fraud against a customer, they will lose any advantage they might have enjoyed in arbitration. Instead, they'll have to defend their actions publicly in a far more equitable forum, a court of law. Of course, this bill does have its opponents, those who want to hide wrongdoing and let it fester rather than making the amends that they should. One argument that's been circulated is that the bill discriminates against arbitration, but the only thing SB 33 discriminates against is corporate fraud. I'm proud to say that SB 33 has earned the broad support from many, more than 24 state and national consumer groups, many of them represented here today behind me. A full list of the supporters materials that were passed out, but here on stage with me today, I'm just happy to say, Richard Holober from the Consumer Federation of California, Brian Kavatek of the Consumer Attorneys of California. Both of these groups are co-sponsors of this bill. Paulina Gonzalez from the California Reinvestment Coalition, Henny Kelly from the California Alliance of Retired Americans, Emily Rush from CalPERG, Geraldine Stapleton, California Now, Carol Sewell, California Commission on Aging, and we also have Mariko Yoshihara from the California Employment Lawyers Association, and we have several members of the Student Senate for the California Community Colleges. And I thank you all very, very much for being here today. And this measure also, at this time, is being co-sponsored by the consumer, well, you've already heard that, but also by Treasurer John Chung. And I'm so honored to be able to work with Treasurer Chung on this issue and many others, and I know he has some things to say on this issue. And Treasurer Chung, thank you. Thank you.
Well, good afternoon. Thank you, Senator Dodd, for that introduction and for your generous and thoughtful leadership on this issue. It is a pleasure to be here today to announce my sponsorship of Senate Bill 33. A little more than 7 months ago, I made a decision as your state's banker to sanction San Francisco-based Wells Fargo. This move came after the bank's admission, as the senator stated earlier, that thousands of its employees opened more than 2 million fraudulent customer accounts. This act drained unearned fees from the accounts of clients, particularly those in Southern California and also throughout California. Many of the victims, as the senator also stated, were elderly or immigrants who were hurt by reduced credit scores and higher borrowing costs. Through the revelation of Wells Fargo's widespread misconduct, which dates back to 2002, Senator Dodd, consumer groups, and I became aware of the need for Senate Bill 33. Wells Fargo put salt on the wound of their victims who tried to sue by forcing disputes to be resolved through forced arbitration instead of a public courtroom. Wells Fargo argues that the arbitration clause is included in the legitimate contracts customers signed to open accounts also covers disputes related to bogus ones set up with their consent. Now, instead of allowing victims to have their day in court, where an independent judge or jury can arrive at a verdict following an open and fair trial, Wells Fargo pushed its customers seeking justice into forced arbitration. While the bank's latest marketing slogan is, "On the side of customers," it continues to deny its victims their right to be made whole by coercing them into secretive process that tilts heavily in favor of corporations. The bank perpetrated our gargantuan fraud and now wants to settle grievances under forced arbitration that they claim covers bogus accounts. This legal tactic is both plain wrong and morally repugnant. That is why I'm sponsoring Senate Bill 33, authored by Senator Dodd. This bill will be heard at 1:30 this afternoon in the Senate Judiciary Committee. Passage of Senate Bill 33 would halt the abhorrent and dishonest practice by Wells Fargo and other corporations. It would authorize judges in California courts to deny petitions for forced arbitration of disputes if a customer was the unknowing victim of fraud involving the unlawful use of their personal information. By putting SB 33 on the law books is only a part of my plan to curtail unfair business practices at many of our country's largest banks. Now, unfortunately, what happened at Wells Fargo was not isolated, but indicative of a growing breakdown of integrity in the culture of too many of our financial institutions. At a time when the White House is rolling back consumer investor protections, California must lead in the fight against deceptive marketing, discriminatory lending, unnecessary fees, illegal kickbacks, and other abusive banking practices. In September, when I announced my sanctions against Wells Fargo, I said that my office would form a task force comprised of distinguished academics, financial regulators, and consumer advocates who are charged with crafting actionable recommendations to federal and state policymakers about how to reform the retail banking industry. Today, I am formally unveiling that task force. I'll present it a little bit later. This task force will work with my office on eliminating the practices I stated earlier. The information that we will gather will be given to lawmakers like Senator Dodd for their consideration. Together, we will work to protect Californians from fraud and corporate abuse and keep companies transparent and honest. Thank you.
Thank you very much, Treasurer Chung. I really appreciate your work on behalf of consumers, and particularly this case here, and working with me on this bill. Now I'd like to welcome Richard Holober, Executive Director of the Consumer Federation of California. Richard?
Thank you. Good afternoon. First, I want to thank Senator Dodd for authoring this very crucial piece of consumer protection legislation. This is a vital bill for protecting Californians. And I want to thank State Treasurer John Chung for both his sponsorship of this bill and for his leadership, really leading the nation when the scandal about Wells Fargo broke, saying California is not going to aid and abet by doing business with an outlaw bank. And that's really what we're talking about here. You know, people open bank accounts for very basic reasons: a place to deposit your paycheck, an account from which you pay your bills, maybe have a credit card or debit card to pay bills, save money for retirement or other purposes. And when we open an account, maybe in the back of our mind, we know from time to time there are bank robberies. But no one in their wildest dream would imagine that they are going to be robbed by their bank. And that is exactly what Wells Fargo did to 2 million customers: stole their identities to fraudulently open accounts. For what reason? Driven by corporate boardroom and top executive level edicts saying open accounts at all costs, at any expense, who aided, abetted, and condoned this massive fraud against over 2 million customers. And the customers were robbed twice. Not only were these accounts opened secretly without their consent and at their cost, but when they went to get justice, they were denied the opportunity to get into a courtroom because an account they legitimately opened extended this arbitration provision to also cover accounts opened through criminal fraud. It's an absurd result, but unfortunately courts have found that this absurd result keeps us from having our day in court. Senate Bill 33 will create room for victims of fraud and identity theft that are victimized by their own bank to be able to have their day in court, and that's the best place for justice to occur. Thank you.
Thank you very much, Richard. Now I'd like to introduce Brian Kabatek, past president of the Consumer Attorneys of California.
Good afternoon, Brian Kabatek, K-A-B-A-T-E-C-K, former president of the Consumer Attorneys of California, currently chairman of the board of Loyola Law School. This is a critical issue to people in California. And the reason it's critical is, make no mistake, that the bank was able to do this because it knew it would hide behind forced arbitration. It knew that forced arbitration was going to protect it from having its day in court, from being held accountable. And it's happened before, and it'll happen again. And I am most grateful, our organization is most grateful to the senator and to the treasurer for their hard work on this. We are going to stop this tide of unnecessary forced arbitration in cases where the people didn't even consent. Now, our opposition has said this is constitutionally invalid. It is not. This is not a contract that people consented to. Basic rules and laws of contracting hold that you can't, there has to be a meeting of the minds. There's no meeting of the minds when consumers are ripped off by their banks. Billion-dollar financial institutions that do business in the state of California have got to realize that they can be held liable in court they can be hauled before a judge and jury and be held responsible. This is not a widespread bill. This is designed to specifically stop the kind of actions that occurred here. So we're pushing forward on this because we need to protect the consumers, the 40 million people in California that deserve protection from corporations. And stopping forced arbitration in these limited circumstances is the right thing to do, and it's the time to do it. So thank you.
Thank you very much, Brian. I'm going to call back up State Treasurer John Chung to introduce the task force, banking reform task force. Thank you, Treasurer.
Thank you again. So I am now very pleased to unveil the members of our Banking Reform Task Force. I am very excited to have Mr. Frank Partnoy as chair of the task force. Mr. Partnoy is the George E. Barrett Professor of Law and Finance at the University of San Diego School of Law. He will be joined on the task force by co-chair Anat Admati, Professor of Finance and Economics at Stanford University. Scott Syfax, founder and board chair of the Nehemiah Companies. Christine Tetro, staff attorney for the Consumers Union. Raul Vasquez, CEO of Opportune. And as mentioned earlier, Paulina Gonzalez, executive director of the California Reinvestment Coalition. Paulina is here with us today and will now say a few words about SB 33 and our Banking Reform Task Force.
Thank you, Treasurer Chung, for your leadership on this issue, and thank you, Senator Dodd, for your leadership on SB 33. This is a really important issue. Every day, community organizations that belong to our coalition work to help people build their finances, whether that's something small like opening a bank account or something larger like a small business loan or getting a mortgage to become a homeowner and take part in the American dream. So when we hear about a bank that was opening fake accounts for people for profits, it's deeply troubling. The new allegations that we heard last week that Senator Dodd talked about, where the bank Wells Fargo was targeting new immigrants, this is predatory behavior by a financial institution, and it is especially troubling on top of all the other 2 million fake accounts that we heard about. Part of the reason Wells Fargo was able to pull off this fraud for so long is because of the forced arbitration clauses that was included in the bank's fine print, even for the fake accounts. In other words, Wells Fargo engaged in a widespread campaign of identity theft against its own customers. But customers still can't sue the bank. So we're proud to stand here today in support of SB 33. If enacted, this law would prevent banks like Wells Fargo hiding behind fine print to force their customers into forced arbitration, where the outcomes almost always favor the banks. Californians are entitled to transparency. We deserve not to have our identities stolen, to have fake accounts opened in our names, to be targeted for predatory financial institutions for identity theft, and we should have the ability to seek relief through the courts when a company like Wells Fargo violates our rights. SB 33 creates that relief. Lastly, I am proud to be named to Treasurer Chang's Banking Reform Task Force. The task force will bring together diverse voices to make recommendations to state and federal lawmakers and regulators on how to reform the retail banking industry. Just a couple of weeks ago, we learned that the Office of the Comptroller of the Currency failed to heed hundreds of red flags at Wells Fargo about the fake customer accounts. Today, Congress is having a hearing to weaken the Consumer Financial Protection Bureau. The time is now for California to do better. Thank you.
Thank you, Paulina. And for more information about my Banking Reform Task Force, you can visit treasurer.ca.gov/BRTF. Thank you, Senator Dodd.
Thank you, and Paulina, thank you for being here today. I think at this time we'll take questions if there are any. See, we all must have just done a very good job describing this bill. So there's absolutely no question. Well, fantastic. I appreciate, first of all, I appreciate all of you being here and supporting this bill. As Treasurer Chung indicated, I will be at 1:30 today in the judiciary hearing on this bill, and look forward to your support there as well. For those of you here in attendance, thank you also for being here. Good day.